The fifth or last exception regarding liability in tort is private defense. So, what exactly private defense means? So, we'll discuss the very meaning of private discussion with explanations relating to private defense. So, regarding the meaning of private defense, no action is maintainable for damages done in exercise of one's right of private defense of person or property, provided that the force employed for that purpose is not out of proportion to the harm apprehended. So, this defense, as the explanation we discussing, is available on the acts done for one's wife or husband or parent or children or in between the master and servant, the use of deadly weapon to prevent harm in response to a simple push or blow with hand are out of proportion and are not justifiable. So, the very test for application of this exception rests on honest and reasonable belief of immediate danger. And in that connection, we would discuss one of the most important leading cases, that is Turner versus Jagmohan Singh, and it was of 1905, and the judgment was made by the Allahabad High Court. The Allahabad High Court held that the plaintiff was not entitled to any damages. As regarding to the facts of the case, it was regarding the vicious stallion of the plaintiff repeatedly attacked the mares of the defendant. So the defendant inflicted severe wound on the stallion, which caused the death of the stallion. So here the very plaintiff was not entitled to any damage, as because it is falling under the very exception private defense, as because repeatedly the plaintiff's stallions attacked the mares of the defendant. So the defendant took necessary action, and that caused severe wound on the stallion, and which ultimately led to the death of the stallion. And in our second important leading case regarding private defense is I.Morris versus Nugent, and it was a case of 1836 and decided by the Court of Appeal. And here it was the very circumstance, and regarding that it was held that the defendant could not take the defense by shooting the dog of the plaintiff, which was running away. So the defendant was not justified in doing so. So the very fact of the case in I.Morris versus Nugent, the dogs of I.Morris, which repeatedly entering to the premises of the defendant, but when he was running away, it was not falling under private defense by shooting the very dog which was running out of the premises. So, in our next leading case, and that was an important leading case, and that relate to Devendra Bhai versus Magha Bhai, where it would be held that under Indian law, self-defense as a permissible defense against an action in tort has been as held by the Odisha High Court in 1986 in the case Devendra Bhai versus Magha Bhai, and it extends to protect oneself and protecting life of his wife, parents and his children. So this is not only confined to the defendant, it extends by protecting the life of his wife, parents and his children. So it also extends to whenever master took any steps regarding private defense of his servant, so also if the servant takes any steps to save the life of his master falling under private defense, the very actionable claim is not entitled to any damage, so it is not falling under liability in tort. And this very provision of private defense under law of tort is given statutory recognition under section 96 to 106 of the Indian Penal Code, which are applicable. Section 96 to 106 of Indian Penal Code, which are applicable to criminal law, has been imported successfully into the law of torts. So, as we have discussed those leading cases regarding this particular exception of private defense, so to reach the very conclusion, we arrived at the point that regarding private defense, there must be some proportion of force or action in relating to the very cause which compels one to take some necessary action in the plea of private defense. So the very need of proportion is important in the very idea that private defense, wherever takes the plea as an exception to liability in tort.